mandatory minimum sentences are just that. It's where Parliament has said for certain kinds of offenses, if you commit the offense, you have to go to jail for X number of years. The problem with sentences of that nature is that a judge could have somebody that's in their courtroom, they committed this crime, and they're forced to send this person to jail for, say, 3 years, but they don't want to. They're able to hear about this person's background. If it's a really young person, like an 18-year-old, grew up with sort of sympathetic situation, they can't factor in any of these things when deciding what the sentence is. They're constrained by the mandatory minimum and they're forced to send a person to jail. The reason why this case was important was the first time in a really long time where the courts say that the mandatory minimum sentence is unconstitutional. We are going to take it out of the criminal code. If a judge has a person who's committed the offense, they can sentence the person in a way that they think is appropriate. Following Noor, a whole bunch of other mandatory minimum sentences were found unconstitutional, and just recently there was a bill that was passed that has removed more mandatory minimum sentences. So I came on at the Court of Appeal stage, and then it was struck down at the Court of Appeal, and it was appealed by the Crown to the Supreme Court, and then I stayed on at the Supreme Court level. So it was really cool because in law school, you hear about these really important decisions that change the law. You hear about it, you read about it, and now I got to be counsel on one of these really important cases. It is the case that is talked about for a particular provision of the charter in law schools.